Good evening, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Wanted to talk to everybody tonight about the perfected security interest. And first, I want to start out with a post that I put up just a little bit ago about the word perfect and the way it's spoken about in the Bible. And I hope people will go back and look at that and see that in the scripture itself, we already have a perfected interest in everything through our own grant of dominion, through our own creation. And that is a grant of the right to use everything that we have available to us. Everything is freely given, and we have a right to use that. And that's what this is all about, is perfecting your security interest in the use of. And so I want to start out tonight with the UCC code, of course, because that's where we see the talk about the security interest, the secured party creditor and stuff like that. And dang it. Get it right, Keith, get it right. And the thing with the UCC where it talks about the secured transactions is UCC 9. And if you're familiar with the notice of consumer goods that I put out in regards to automobiles, that's where we have 9-102, wherein they give the definitions of consumer goods. And that's what we're talking about. It's consumer goods. Consumer goods, you have a right to own privately. You have the right to use them privately. And when we talk about the word consumer, what is a consumer? Somebody that consumes something. Somebody that uses things. And so as a secured party creditor, known as a consumer, we're the ones that provide the secured transactions. However, we're not securing them because we're not providing the security interest in them. And so that's what we're going to talk about tonight. And when you learn, like I've been expressing, the scriptures, it's a detailed map of how to behave as a steward of God in His house, while using such things as persons for commercial transactions. And here we talk about secured transactions. So we have to provide a secured transaction first to perform those commercial transactions diligently, without fraud and without taking advantage of our brothers and sisters. And so the Title IX of the Uniform Commercial Code talks about secured transactions, and it starts out with 1-101 is the short title, and then, like I said, 9-102 is where we talk about the definitions, where it gives us the definition of consumer goods. Consumer being one that uses, and in our secured position, which we'll talk about here in a bit, the position that we hold is as somebody that's already been granted use of everything that's available to us. It's already been freely given. It is free of levy, free of taxation, free of any tithe. Okay? And all we have to do is announce that we know our secured position in that. When we talk about perfecting the security interest, we see 9-312, and it talks about perfection of security interest in chattel paper, deposit accounts, documents, goods covered by documents, instruments, investment property. They don't say whether it be tangible or intangible. Letter of credit rights. Not the letter of credit itself, but the letter of credit rights. Not privileges, not immunities, not some kind of grant. Rights, inherent rights to the letter of credit. And the letter of credit is seen in the Constitution. That's the Commerce Clause. 12 U.S.C. 411 in the Federal Code. That's lawful exchange of or lawful exchange or exchange of lawful coin, lawful money. And then right after that letter of credit rights, it says, and money, perfection by permissive filing, and temporary perfection wit. When we read this section, it starts out, perfection by filing permitted. Okay, they're going to give you permission to file in their system your perfection. Okay, the thing about this is they're not going to recognize your perfection until you do that, until you show somehow that it's recorded. Now you can record it in your own, but they're still going to require a UCC1 lien. That's your perfection in their realm, in the document realm. Okay, but we're going to get onto that here in a little bit too. It says a security interest in chattel paper, negotiable instruments, or investment property may be perfected by filing. Now, one of the things I want to point out here to everybody is we've already discussed in definitions what instruments are, and under the definition of instruments, it says instruments are negotiable instruments. So right here, they've already stated a redundancy: negotiable instruments and instruments. And we see that because negotiable instruments isn't blue line highlighted, but instruments is. So when we click on that blue line highlight, instruments, it takes us to the definition of instruments and says instrument means a negotiable instrument, or any other writing that evidences a right to the payment of a monetary obligation, is not itself a security agreement or lease. But it does state that evidences a right. Letter of credit right. Okay? So then the next one says, B, it says control or possession of certain collateral. Certain collateral. Except as otherwise provided in section 9315C and D for proceeds. A security interest in a deposit account may be perfected only by control under section 9-314. Only by control. A security interest in a deposit account. Here's where we're going to talk about deposit. Now remember, when we break down terms and conditions, we see that we have a deposit account. And we're going to look at deposit. What is deposit? Well, when we think about deposit, in my eyes, we think about disposal. Well, what do you mean disposal? Well, we're dispositioning something. We're depositioning something. That's what a deposit is. They are depositioning. And what we have to do is reposit. We have to reposition ourselves. We have to put ourselves back in the position as the secured party with paramount interest, because we are the true and original creditor. We are the true one and only that can consume. The person cannot consume. Okay? So that's what a deposit account is, and we're going to reposit by repositioning ourselves, by placing that security interest through the UCC1 lien, the authentication of the birth certificate. And we're going to talk about that next. 9-313 says when possession by or delivery to secured party perfects security interest without filing. Permitted filing. And then in 9-313 it says when possession by or delivery to secured party perfects security interest without filing. Perfection by possession or delivery, except as otherwise provided in subsection B, a secured party may perfect a security interest in negotiable documents, goods, instruments, money, or tangible chattel paper by taking possession of the collateral. A secured party may perfect a security interest in certificated securities by taking delivery of the certificated security under Section 8301. Birth certificate is a certificated security. And under 8-301 says delivery. Delivery of certificated security to purchaser occurs when? And when you pay the Secretary of the State that $25 fee for your certificate of live birth, you have paid for the delivery. You have not paid for the document, you have paid for the delivery. The purchaser acquires possession of the security certificate. You now have possession of the security interest. You have possession and you have right of possession. So now you have legal title and equitable title. Got that? The purchaser acquires possession of the security certificate. This, when possession by or delivery to secured party perfects security interest without filing. Just having that certificate of that security certificate delivered to you and you now possess it, you have perfected that security interest. Okay. 9-314. Perfection by control. A. Perfection by control. A security interest in investment property, deposit account, letter of credit rights, or electronic chattel paper may be perfected by control of the collateral under 9-104, 105, 106, or 107. Notice it doesn't say all of them. It says one by one or the other. 9-104, control of deposit account. What is a deposit account? Ask your banker if that personal account you have is a deposit account or a savings account. Secured party has control of deposit account if the secured party is the bank with which the deposit account is maintained. Can you prove by control that you are now the bank? Can you prove now by control that you are the transfer agent for all instruments that go through that deposit account by letter of credit rights, as secured party of interest with paramount interest, as executor, as holding office of the executor of the estate? The executor of the estate is a person, and you hold office of that person. You are the only one that can hold that office. How? Because you now have control, both legal and equitable title of that office, and can now hold that capacity and assert it properly in law, on and for the record. The debtor, secured party, and bank have agreed in an authenticated record that the bank will comply with instructions originated by the secured party directing disposition of the funds in the deposit account without further consent by the debtor. Read this section. Read this very well. The debtor, the United States, secured party, and the bank with the deposit account have agreed in an authenticated record. It's been authenticated by operation of law since they delivered it to you. You are the only one they can deliver that to, that can hold the position of office of executor of the estate. They can only hold trustee position. Period. And you yourself, as the secured party, as we'll see here in a minute, are the beneficiary. And as beneficiary, you hold the office of that person. This is your duty. The secured party becomes the bank's customer with respect to the deposit account. Okay. Deposit account means a demand. What's a demand? An order. What's an order? A draft to pay. Time, savings, passbook, or similar account. So if you've got a personal savings account, it's still a deposit account maintained with a bank. The term does not include investment property or accounts evidenced by an instrument. The term does not include property or accounts evidenced by an instrument. Well, what is an instrument? It's a negotiable instrument. Negotiable instrument either has to be passed on to somebody in investment or deposited into account, you would think. Or accounts evidenced by an instrument. So an account is not an instrument. The deposit account is the account in which the instrument is deposited in. So whose account is that instrument now deposited in? As holder, controller, with both legal and equitable title, you are now the one that has evidence in the instrumentality. The term does not include investment property, but it does include collateral. Okay? So now we go on to 9-105 is one of your other options. Control of electronic chattel paper. General rule, control of electronic chattel paper. A secured party has control of electronic chattel paper if a system employed for evidencing the transfer of interest in the chattel paper reliably established the secured party as the person to which the chattel paper was assigned. Okay, so in this section here we see that the system has to have a record. In other words, now this is where you have to file for that electronic proof. You have to show that you have control of the electronic chattel. So you have to file in their system. Otherwise, technically, somebody across the country could enter in Keith O. Little into a system, and there actually be another Keith O. Little in the system on the East Coast that they could enter, but it might somehow get construed and end up on my plate. So as long as I have my record in there, it would show a difference. Their records would show an error somewhere that they could not associate with me simply through Keith O. Little. It would show that it would be Keith Orville Little or something like that. And of course would lead to a difference in the numbers and the QSIP numbers and all this. So control of electronic chattel is only there for internal errors in my opinion. Because as long as you still hold that control of that collateral by possession, you have the ability to show that as a private document. You do not have to authenticate 10 copies and then give away that authenticated copy. That's an instrument. It's a negotiable instrument. And though you may have created a debt payment instrument out of it that is now stopped. They can no longer negotiate it. It still becomes an instrument that doesn't really do much anything else except for each incident, which you could do that simply through your PMA and holding that in the PMA and showing that you control it and that the state no longer controls it, and you know that you have control of it because you only need the one and no longer require the state to deliver it to yourself as a customer because you've already bought one. You've already paid for the delivery of one. And you have a receipt showing that it was delivered. Delivery, just like deposit. You now have relivery if you give it to somebody else. B, specific facts giving control. A system satisfies subsection A if the record, again, it has to be recognized. You have to place it into their record. So you have to do some kind of filing. That was in the 9314 or something, I think we talked about filing. Permitted filing. A system satisfies subsection A if the record or records comprising the chattel paper are created, stored, and assigned in such a manner that a single authoritative copy of the record or record exists, which is unique, identifiable, and, except as otherwise provided in paragraphs 4, 5, and 6, unaltered. Okay, now this is what I'm talking about when you take that birth certificate that you had delivered from the state and you deposit it in your PMA. You don't need to authenticate it. You can authenticate it and then deposit it. But authentication just means it's now been filed in their system and you have proof that it's been filed in their system. But you can also do the UCC1 lien, which authenticates it. Or you can authenticate it by adding it to your PMA. By operation of law, it's now property, and you have a receipt showing it as property that was delivered by the state as a instrument, financial instrument. The only problem I have with this part of it is that I can't substantiate that part because I don't know exactly if this particular instrument has a expiration date. I don't know the exact financial laws of what these notes are about, how long they take to mature, if they actually have to be forwarded to another entity to set off the debt, or if there's just proof of them in the existence. Not quite clear on that, but I'm pretty sure that it's set up so that all you have to have is control of it. You have to have possession of it. You can show it as a private possession of chattel documents, chattel record from their system that clarifies that you are the secured party in interest. It wouldn't be clarified any other way because they can't deliver it to somebody else and then that somebody else present it as a private document that they have right to. I'm the only one that has a right to that birth certificate to be able to put forth the capacity of holding office of executor of the estate. So this is why control is one of those words that is so important. Control of electronic chattel paper is just merely proving through record of operation of law that it was created for my benefit, and that benefit exists prior to that through a statement of being born live, a born live statement, and that itself is self-authenticating. See what I'm saying? It's recorded both in the death records at the local county register where I was born as a live born statement, and then the state had possession of a death certificate, technically a death certificate that they had delivered to me. Now, if I turn around and take that and recorded another document, hand-drawn document, proving that I have receipt of that particular instrument and recorded at the original jurisdiction, county of original jurisdiction, where it originated from. Now I have technically dry docked back into the county of original, the the court of original jurisdiction and match those records. Now they match. No longer lost at sea. I found my port. I found my home. And now I can travel freely. Okay? Very important to comprehend how this works. A single authoritative copy of the record or record exists which is unique. A single authoritative copy. That's the copy I hold. That's the one copy I hold in my PMA that exists that I can prove on and for the record. And it will cost anybody to see it if they don't believe the record that I've already established on and for the record at the county register that it does exist. Nobody rebutted it, therefore it must exist. Now, if they want to see it, there's a financial charge for that because now we're entering a commercial agreement. Commercial agreement that they're saying that they showed it existed. They sent it to me. I filed a document affirming that it exists, showing the receipt that you sent it to me, thereby doing two witnesses, giving it to a third witness, who happens to be the original jurisdiction. Think about this. Unaltered. 2, the authoritative copy identifies the secured party as the assignee of the record or records. Okay, who is the assignee? He is the creditor. He is the executor. He's the one that, the executor is the one that assigns the trustee and the beneficiary in an estate trust. Okay? And so 2 says the authoritative copy identifies the secured party as the assignee of the record or records. Again, it's reaffirming control of the electronic chattel simple by operation of law. You do not have, this is once again confirming I shouldn't have to file anything, in my opinion. The authoritative copy is communicated to and maintained by the secured party or its designated custodian. I am the custodian of my records. Therefore, I am the designated custodian as well as the secured party, unless I assign somebody else as custodian because I am the secured party as the authoritator. I am the one that has the copy, and they gave it to me through a communication of delivery. Pure and simple. So anyway, now we're going to go on to 9-106, which is the next option. And 9-106 says control of investment property. Now this is where we talk about using that collateral in a securities market. In other words, if we go into one of these cases, we get drawn into court, we go ahead and accept the offer to contract by making certain amendments, accepting it by putting terms and conditions on it, those amendments, and then giving it back in the proper status where we're going to reposition ourselves as the principal investor so that the banks can't shuffle this promissory note around in the background. But we're the principal investor. Now we get to hold that promissory note. We get to draft the order of payment when the dividends are returned upon the investment. We exchange that promissory note when the dividends are returned, and now we're responsible to have that person, the trustee of our person, or our person of trustee, pay the taxes. And as, again, beneficiary, we receive the proceeds. Proceeds. Proceeds, except as used in Section 9-609B, means the following property: whatever is acquired upon the sale, lease, license, exchange, or other disposition of collateral. Other disposition of collateral. Proceeds. And that's what these courts are depending upon when they run these cases and shuffle all these bonds behind the scenes. They're relying on the proceeds. The proceeds are the dividends that are paid off the securities when they're traded on the domestic here locally within the states, and then foreign securities once the case is over with. The bonds, those notes have matured after a year, and they sell them to the federal government, who then trades them on the open markets in the foreign international trades. So think about this stuff, people. All of this stuff is important in order to be able to put it all together and find out what you're doing in all of these commercial and secured transactions. They're all the same as long as you know that you're the secured party already. All you have to do is know this and know how to show them. And it's all there. They've already put it out. And again, that's why I hope people will look back at my previous post on the biblical writings on perfect. And those aren't the only ones. There's many, many writings in the Bible about perfecting yourself in the ways of God. And that's what this is all about. God is teaching us how to perfect ourselves in our everyday workings with our brothers and sisters. And that's why it's so important to comprehend that every contract itself starts with arbitration. It starts with going to our brother and speaking to our brother. Period. Whether there's a controversy at hand or not yet, it starts with arbitration, and that's a discussion, that's a debate. We start talking about things. And that's why contract is law and law is contract. Because we first must go to our brother to speak. In beginning was word. And so when in beginning was word, and we build a trust with each other that, okay, I'm going to go back home, I'm going to grab my oxen, I'm going to come over and plow your field while you and your wife beat up this batter or churn up this batter and make me a couple loaves of bread and round up a couple chickens for me. You know, through this agreement, without a commercial transaction, we're securing ourselves in our own words. And by following the word of God, we perfect ourselves in our words so that when we get into these contracts, we can actually walk into these courts without fear in our heart, love thy neighbor as thyself, and say, listen, brother, you know, I see that Officer so-and-so has brought a charge. I'd like to present the information to show that I am the one that's actually needing to ask forgiveness from the court in hopes that they accept that I forgive them in bringing these frivolous charges. But now that I've been drawn into them, here's my fee schedule accordingly, and da-da-da-da, you know. Explain to them that, listen, according to the Word of God, I comprehend that you're acting under Romans 13, but through government officiating, we're supposed to be ministers of His Word still. And in the ministry of His Word, in order for me to perfect things here, I need to show it on the record. So while the plaintiff has brought information that points out to certain things in the record, I'm going to fill in the gaps that are missing to show you the chain of control. So long as I follow His way, I shall be blameless. And so, and that's why I do this stuff. I try to point out that it's all in, it all works right with the teachings of arbitration. Matthew 18, verses 16 or 15 through 20 talks about when we go to our brother who has brought something to light that might be controversial or has made an accusation, we're supposed to go to him in private first. Well, that's what we do when we ask somebody for help in anything that we do, is we go to our brother in private first. We don't make a public announcement that we want this brother to come help us. We go to him first. And that's our first part of due process in everything we do. And in doing so, we're supposed to go to him in love. Love thy neighbor as thyself. And accept that he might have made an error, and so we don't blame him for what he's done. We just go to him and present the valid facts that, hey, you know, while I see that there's a charge of $150 for driving, I have to amend it, conditionally accepting with a arbitration clause so we can keep this on the private side, because I comprehend you, even though you accosted me in the public, you were acting in a private capacity, being privately hired by a private corporation with this DUNS number, so I'll keep it in the private capacity and da-da-da. And done right, you know, you start pointing out the truth to them in the right way, and they'll see the error of their ways, and not only have you now perfected your way, but you've helped educate somebody else in their wrongs. You've helped show somebody how they have been acting imperfectly. Even though he may have gotten that job to uphold the law of God because he's a God-fearing Christian, he may, just like I and many others, been steered down the path in full fog of indoctrination and cognitive dissonance of convenience. And that's all we got to do is point that out to him. You know, hey, I was I was on the comprehension that this instrument was created because I was born and was conveyed into a person for my use as a benefit. And that benefit is clear through my possession of this particular document. This one single document shows that I have an inherent right. This is a letter of credit. And I have a right to it. Well, what is that right? Well, that right is entitlement and enforcement of all secured transactions as principal investor. Period. Plain and simple. Because without myself, nobody else would have this instrument. It would not exist. Period. Plain and simple. So, control of investment property is that which you have a bearer form. You hold the collateral itself, the birth certificate. That is the bearer form. The bearer of this instrument. It has secured party interest. Paramount secured party interest. It proves he is the principal investor. That bond cannot be traded unless he says so. He is the executor. He holds office of the executor of the estate. He's the one that gives the assignments. He's the one that assigns a promissory note. Pure and simple. The next one, of course, is 9-107, was it? Yep. And this is the last one. And like I said, this is all just different options. But as we see here in 9-107, it says control. And notice these all say control, and that means possession. Or proof of the paramount interest. Control of letter of credit right. Control of letter of credit right. Now comprehend that birth certificate, like I just said, is the letter of credit right. It's proof of the letter of credit right. And you have control of it. It's the certificated security. It's the instrument. And it shows, it proves, just holder of it, that you have both legal and equitable title as holder of the office of executor of the estate. And now we're talking about control of letter of credit right. And it says a secured party has control of a letter of credit right to the extent of any right to payment or performance by the issuer. I didn't issue that document. Who did? Who is the original issuer? Like I said, the original jurisdiction. The original jurisdiction is the county registrar that drew up from abstract information a certificated security. Now you have a like instrument that you can match up with that original. Secured party has control of a letter of credit right to the extent of any right to payment or performance by the issuer of any nominated person if the issuer or nominated person has consented to an assignment of proceeds. Again, proceeds comes from investments. So we have to talk about, are we investing here or are we asserting our right of control? to an assignment of proceeds of the letter of credit under Section 5114C or otherwise applicable law or practice. Again, applicable law or practice, we're talking about control of the letter of credit. We have control of it. Therefore, we say whether anybody else issues anymore. Period. So, just having it delivered, just calling the Secretary of State up and having that one document delivered shows that you have control. Now, another thing that we can also do, and it doesn't have to do directly with the birth certificate, but actually prior to the birth certificate, again, is that born live statement. Now, if we have both the birth certificate and the born live statement in our control, and we enter a document pertaining to that information, now there is no disqualification that can be had anywhere, because we now have a document registered at the original jurisdiction, the county of register that originally took the born live statement, created a certificated securities so that it could be invested, deposit account. He dispositioned the investment authority. We now reposit those instruments to ourselves. We now have a born live statement and the birth certificate in our position, in our possession. It is positioned with us. It has been reposited with us. We are now accountable. And as accountable party, we are the only ones that can issue any other attachments to that security. Period. Why? Because we now control it, and we have record that we control it. They now have record that we control it. That record is a recognition that we control it. And through your certified copies, you send out certified copies to 120 different departments, agencies, programs, actors, agents, whatever. Let it be known throughout the world. I am already secured party. And now it is recorded both on my record and on and for the public record for all to know for time immemorial, here and ever after. And that's all that needs to be known. You want to see these documents? You want to see these instruments in private? We'll have to have a contract. You'll have to come speak to me in person or in private. You'll have to perfect your willingness. You'll have to perfect your interest in seeing these documents any further. Pure and simple. Because so long as I follow his way, I shall be blameless. So until then, you have nothing to blame me for anymore. You can't blame me for acts of persons that I haven't been acting for and that I haven't issued. That would be your issue, and you issued a false instrument. Plain and simple. Now, I'll accept this instrument on the condition that we take it to arbitration because you did offer it in private. Therefore, I'll keep it in private. But we're going to get the wheels rolling on this one now, because now that you've offered it, it is a certificated security, and I'm willing to play this game now. Because as I see it as a principal investor, as long as it's a good investment and it brings back proceeds, dividends that are going to benefit myself, so long as I take care of the taxes, hey, I'm sure somebody else will make a little bit of money on this too, but I'm the principal investor. I'll make the principal dividend proceeds. Since it's my principal decision, my principal assignment, I accept that duty. I accept that responsibility. I accept that reposition. But you got to know this. You got to know how to stand up for it. And that's why I urge people to read this stuff. The last section I want to talk about is 9-315. And in 9-315 it says, secured parties' rights on disposition of collateral and in proceeds. Now, this is talking about your secured party's right on the disposition. In other words, they're telling you it's already been dispositioned. They're telling you it's already been dispositioned. And that's why I say once you get that birth certificate, known as collateral, you have now repositioned it. Rights on secured parties' rights on disposition of collateral and in proceeds. Now, what are the proceeds? Are all the proceeds from the past? Are they proceeds just from the present? Are they proceeds that will be derived in the future? They don't discern this. Why? Because they can't. That would be clarifying a fraud. You have a right as a secured party in all of the proceeds. It's all been contract. And all contracts contain an arbitration clause. Why? Because, like I said, contracts start with arbitration, and it is mandatory that they proceed with arbitration. Otherwise, it is breach of contract. And then you have a tort. When you go into these courts disputing these charges and everything, you're breaching the contract. Why? Because you don't know his word. And you don't know their word. That's why you're babbling. When you learn his word, he teaches you how to talk to each other. He teaches you how to come to each other in love and peace and say, okay, well, let's think about this in common logic and rational ways then. Because when you go forth in love and you realize that you don't have that fear in your heart anymore, you can do that. Disposition of collateral. Continuation of security interest or agricultural lien proceeds. Agricultural interest or security interest or agricultural lien proceeds. Agricultural lien, where do we hear that one? That's the UCC1 lien. Soon as you slap a UCC1 lien on that thing, you've got the agricultural lien. You've got the inherent secured party rights of interest, position, collateral, possession, both legal and equitable, of all controlling factors. Period. Period. Because it's your rights. And it's their privilege to use them. So forgive them their misuse of their privilege use of that instrument. And ask them for forgiveness for not knowing how to use that instrument. But let's perfect the record now. Because neither myself nor you can be perfect, but we can perfect this record. And that's what it's all about, perfecting the record. You follow his way, and he will show you a perfect way. You follow his way, and he will show you step by step how to perfect that record. One step at a time. And that's what this is all about. It's all about a process, and it's all about a process of arbitration, discussing things. It's not about arguing with each other. It's about discussing this kind of stuff out in the open in videos like this so we can help each other. Because even though I'm not in a contract right now, by putting this video out, I'm discussing things. I'm creating an arbitration agreement or an arbitrary setup. I'm going to post this video. There's going to be comments. There's already all kinds of comments. And it's going to continue for a while. Does that mean it's a contract, though? No. It's just a discussion. But when you get involved in discussions of exchanging various different things, whether they be tangible or intangible, then you're talking about a contractual setup, contractual construct. And in that, you have to keep the arbitration going. Once you start an argument, bring in controversy, then you're not doing things in a Socratic way. And Socratic has to do with logic and reason. Logic and reason says, well, as long as I'm doing things for the right way or for the right intent, things should still work out. If I see a problem, then I have to step back and say, okay, let's wait a minute here. Let's think about this again. And that's why I urge people to look at this stuff online, see these blue line highlighted things, click on those links, find out what they're saying, and educate yourself. Learn for yourself. Expand your knowledge. My people shall perish for lack of knowledge. And that is his will, is knowledge. He wants us to go forth and learn and educate each other, to go forth so we can live in prosperity and abundance. If we don't go forth and learn how that plant grows and how it bears those fruits that we can eat, so that we can come back to it the next season at the same time when it's bearing that fruit again, instead of traveling around in a daze and coming upon the same plant at the wrong time and it's not bearing fruit, and we wonder, well, where are we going to get our next meal? We start educating ourselves, so we don't keep going into these courtrooms in and out of this in this natural daze, wondering, well, when am I going to get my remedy? We've got to learn this stuff. We've got to educate each other, and we've got to put it forth. So our secured party's rights, that right there is telling us we're already, the rights belong to the secured party. Well, who's the secured party? Well, it would be the one that the rights belong to. Everyone else that's dealing with this instrument is operating it by privilege. Well, what do you mean by privilege? Well, somebody's assigned it to them, or it's been presumed that there's an assignment. So we have to beat that presumption of assignment and sit in the right seat of capacity as office or of holder of the office of executor. How do we do that? We hold the collateral, showing that we are the ones that control all things. Pure and simple. And again, like I said, I don't believe we have to authenticate the damn thing. You just have it delivered. Once it's delivered, it's authenticated by operation of law. They wouldn't send it to somebody that didn't give them the proper information. Without knowing the proper information. Would they? Wouldn't they be liable for it as a trustee? They can't accept any other position. They can't accept that they're or present that they're an executor. They can't present that they're a beneficiary. They could present that they're co-beneficiary. But that doesn't mean they, as co-beneficiary, they get to execute the estate. They only get to administrate certain affairs. And this is stuff we have to think about, people. So anyway, it says, except as otherwise provided in this article and in section 2-4032, secured parties' rights on disposition of collateral and in proceeds, a security interest or agricultural lien continues in collateral notwithstanding sale, lease, license, or other disposition thereof, unless the secured party authorize the disposition free of the security interest or agricultural lien, and a security interest attaches to an identifiable proceed of collateral. And a security interest attaches to any identifiable proceeds of collateral. So, we not only have to authorize, but it has to be the authorization of an attachment. And when we talk about an attachment, what is an attachment? If we're going to authorize attachment of a security interest to any identifiable proceeds of collateral, we're talking about a contract. So this here, except as otherwise provided in this article and in section 2-4032, a security interest or agricultural lien continues in collateral anytime I contract. Anytime I decide to give an assignment. My rights continue. I cannot give them up through an assignment unless I put it in there. Disposition, authorize the disposition free of the security interest or agricultural lien, and a security interest attaches to any identifiable proceeds of collateral. That means I have to perform a contract. I have to make an issue, and I have to attach it to a contract, so that when the issue returns, or when the dividends are returned on the issue, that attachment, that instrument remains attached to the contract. And this is what they're not doing in the banks. They're drawing up the instrument, that promissory note, but they're not attaching it to the contract, wherein it's supposed to remain with notwithstanding sale, lease, license, exchange, or other disposition thereof, unless the secured party authorized the disposition. And that's what they're doing. When you're signing these bank loans and stuff, there's something in there where you have authorized the disposition. You have authorized the removal of the note. Underhandedly, of course. But that's what they're going to point out. Yeah, you assigned it. You assigned it. How can they say you assigned it? Well, in saying that you assigned it, they're telling you you're the executor. You're the one that holds the office of executor. You're the only one that can assign it. That's why it's so important you read these documents, people, and comprehend what you're assigning. Because whether you like it or not, you are already the secured party. They presume that because it's already known. All you have to do is put it on the record the right way so they can recognize that now you know it. And once you do that, the debtor, secured party, and bank have agreed in an authenticated record that the bank will comply with instructions originated by the secured party directing disposition of the funds in the deposit account without further consent by the debtor. You're the one making the order now. You're the one making the demand. Because you have control of the deposit account. How do you have control of the deposit account? You have control of the collateral. That is the deposit account. Get it? Anyway, people, I hope this helps everybody comprehend what's going on in regards to the Article 9 secured transactions, and you are the secured party creditor already. You are the consumer. You are the one that uses this stuff. You have the right to the consumer goods under 9-102 simply by purchase. So as by purchase, you purchase the birth certificate. You now have the purchase of the birth certificate under 9-102 as a consumer good. A private property that you now hold up as the collateral, known collateral, as controller and holder in due course of all transactions, be they commercial or secured, knowing now, put forth to the world, all be known, I am the secured party. Simple as that. I hold both legal and equitable title, and this here is proof. Now you hold up that original statement of original Born Live statement, along with that shadow paper. You got everything you need to go before any court without handing any documents over. Just take them into private chambers. Sir, I've got a couple documents. I think before we proceed any further, you might be interested into going into the private chambers to discuss with, because if you act inappropriately here in this public venue, you are now moving forward in a contractual venue. All public venues are contract venues. Period. You have witnesses. Use them. Let him know it's up to it's to his wise choice to take these matters in private. Let's talk about this stuff. I believe this is contractual, and therefore it's a arbitration design, and therefore even if the prosecutor and the officer aren't here today, I suggest that we continue in arbitration, and I'll show you documents to prove that the arbitration already proceeding is in error. If you wish to continue forward in these erroneous proceedings, then you can and will be held liable according to the secured party with paramount interest as principal investor in all bonds and certificates being securitized here. You'll know what you're talking about if you say it right. And that's why, again, I urge you, learn how to use the words that they're using in regards to all their banking transactions, and realize you are the bank. You are the holder of the deposit account. You are the bank. You are the one that controls the collateral. You control whether it goes this way or this way. You'll handle all the proceeds. You'll administrate the you'll assign the positions of trust and have the taxes paid for. But you have to step up and comprehend how to perfect that. The only way you can perfect that is through knowledge. Again, my people shall perish for they lack knowledge. Hosea 4, verse 6. And that is his perfect will, is that you gain knowledge. Once you gain that knowledge, have it recognized. Share it. So I urge everybody, think about this stuff. I'll be bringing more. I want to get back to the Child Abuse Protection and Treatment Act. I want to go into that and the Social Security Act a little bit further. But I wanted to bring up this Article 9 of the UCC because it talks about the perfection of your security interest. And I wanted to explain that if you know what's there, you already know. You should realize that your security interest is already perfected. You just have to clarify it. Your security interest is already perfected, and they've deposited it. Deposited it. They've dispositioned it. Depositioned it. Deposit. Position. Depositioned. It's the same thing. And all you got to do is reposition it. So you're going to reposit it with yourself. You're going to hold it yourself. That's all it takes. Possession of the person shows that the person is possessed. And only the one that possesses that person can make assignments. So think about this stuff, people, and remember, if it wasn't for you, I wouldn't be doing this. God bless. Have a great night.